Chacha obi biara edeba daily TRENZ TV eso ensem a editie o my Ghana eno ena yakeka abomu na yede bre ye tiefo yensem re no na yense wadaje no yenko na enkuti ensem no enchemu
ebe kikim Chia and Zoe Chambers, led by astute lawyer Atachia, are filing their friend supplementary affidavit in support of Chairman Wontumi's bail application pending before the High Court after his substantive appeal pending before the Court of Appeal and certain interpretations of the Minerals and Mining Act and also pending before the Supreme Court. On say last week, Chia and Zoe Chambers filed a bail application at the High Court. Say High Court and granted Chairman Wontumi bail pending the appeal a year before the Court of Appeal. And no lawyer Atachia and kase di animo file over 20 grounds on which osusu say the sentencing and judgment delivered by Justice Her Ladyship Audrey Kukuvu Tay ensese ejina na yenyi Chairman Wontumi and free the in Sawa Medium Prison where he is serving 20-year jail term. Now lawyer Atachia filed an appeal because already he made known to the entire nation say the grounds on which Justice Audrey Kokobute delivered a judgment at the sentence Chairman Wontumi no na problematic. Judge ni no the ono ankasa ni tumi ekyerɛkyerɛ mmerɛ bi a ɛwɔ the Mining and Minerals Act mu a saa tumi no Supreme Court nko na Ghana mra edi amano eno nyina so kese a judge ni gina so the sentence Chairman Wontumi the other grounds na over 20 grounds na appeal no gina so eno na just last week lawyer Atachia said debi or share the circumstances surrounding the appeal awaye with the Court of Appeal now we heard Ghana emremu eni nioma bi a wosusu say ebe ye Papa said, "You be granted Chairman Wontumi bail pending the appeal case because Ghana ye dia mani pa bebrebe. Ye bi edema Daniel Azim ya no ye accomplice in the Sedinam Tamaklo case. Ye bi edema Atuesien. Dr. Kwabena Dufo bebrebe ya ye bebrebe. Eruti osusu say ebe ye se ye bi edi ama Chairman Wontumi enti no ema bail application no echo last week. And the Attorney General also filed an application opposing the bail application done by lawyers for Chairman Wontumi. Into her Attorney General basic argument ewo enioma mako miensa so say court ohe na sa bail application no a Chairman Wontumi tuni lawyers epe no court emwonfa ntumu. Attorney General ka say the edikan Chairman Wontumi appeal na nkasa no any reasonable chance of success kire say appeal no eni ahoden a ebetumi adi mu na agina the kind no enunti ehu hia kwa say be man bail because the entire appeal process according to the Attorney General it has no reasonable chance of success. The Attorney General STT said Chairman Wontumi a flight risk onya obedwane profono nyina nchire mu Chairman Wontumi nya obedwane and the Attorney General can say there was this interview by lawyer Andy Apiakubi, the former counsel of Chairman Wontumi, on one TV station. Lawyer Andy Apiakubi can say if not for ono how was he manage the client Chairman Wontumi the character. In fact na Chairman Wontumi aye na adwene say one obe resist arrest, two obe breach bail conditions ana yoko asese de ato hama no na nka wa free oman yimu e de akọ eno ti Omo attach a video recording of that live TV interview as an exhibit to the affidavit. Yo what they call say Chairman Wontumi's bail application yemo emfa entumu. Ebio omo say the kodentia osanya flight risk ni say apart from the Summer Boy case here already watching a 20-year sentence, you know, the other 2 pending cases are very likely say Chairman Wontumi be facing imprisonment for those cases, thereby considerably increasing the number of years I will spend it in prison. And also contribute to the flight risk. And Attorney General SI dispute to be say, or who say a who be here said physically, Chairman Wontumi be present during the appeal. When the lawyer for the Hujuma or no who here already he's been sentenced. And you're granting a bail condition, it is of no consequence. It is inconsequential to the appeal process because he's already been sentenced. La lawyer for all more, ombe to me aye say jumani nyina ede amano. And afei the Attorney General SI rejected the claim said Chairman Wontumi's bail application according to law and yet an exceptional circumstance. It is not an exceptional circumstance. The lawyer for filing said it is an exceptional circumstance because throughout the court proceedings, Chairman Wontumi missing a single court proceeding, meaning say he conducted himself perfectly in the rule of law. And you know, omo esusu say it is an exceptional circumstance. Court to betumi agina so e dey granting the bail. The Attorney General pursue say Chairman Wontumi conducting itself very well during all court proceedings, but Onususu say it doesn't constitute an exceptional circumstance for him to warrant the granting of a bail pending the appeal. And you may a fresh affidavit akopiemu ewa the Accra High Court, accompanied by enormous evidence attesting to the fact that indeed Mr. Bernard Ntwibos Yakon Yadona for the Chairman Wontumi deserves bail, said the lawyer Atachia Ekan. Now, according to the Zoe and Chia Chambers, affidavit no yedi kan kire say and when evidence no a court proceedings since day one a court to say omo agekra tie free court a kire say Chairman Wontumi missing a single court proceeding. He did not abscond from a single court proceeding. Neither did he fail to attend any scheduled hearing. He never evaded the jurisdiction of the High Court. He never jumped bail or breached any bail condition during his entire trials. In all the 3 cases, supported by court evidence from Accra High Court Division 1. Yeah, just a leadership or the Kukubuti sentence Division 10. A honor the Tano Numeri Forest case in the war, and of a Division 11, a honor the Ezen Bank case in the war. To omodi all these court documents supported by an affidavit at the Echo HRSA. Or as someone Attorney General can edi oposu be no enokre bia sani afa de etoso mienu omo sign the second affidavit is supported by statement a free Iyoko. Interestingly, Iyoko the kan Chairman Wontumi, and it was in somewhere April this year. According to Iyoko, omo chi no and omo requested for the deposit of Chairman Wontumi's passport at Iyoko office. And according to Iyoko, since April, it was a D case no Summer Boy case ni wiye e Chairman Wontumi ko tu mu no ebesi enne ya affidavit na ko do High Court. Chairman Wontumi passport e da Iyoko ya omma hokra meji. Omma ho meji. The affidavit states that as part of bail conditions previously imposed on him by the Economic and Organized Crime Office, Wontumi surrendered his traveling passport to the agency since April this year. His lawyers therefore questioned the Republic's reliance on an alleged flight risk that he could flee the jurisdiction, arguing that the prosecution is aware that his passport has been in Iyoko's custody since April this year. The affidavit maintains that Wontumi remains willing to comply with any further conditions the High Court may impose if his application for bail pending appeal is granted. The second affidavit said the Miche a year and Krata a free Iyoko say since April this year, Iyoko Forche chairman a bail condition of 50 million Ghana cedis to no. It was required of Chairman Wontumi to deposit or surrender his traveling passport to the agency. Ya Eda Iyoko. April, May, June, July, August, 5 months in year. Iyoko ama evidence supported by documents. Chairman ma hokra requested that say be a traveling passport e dia yibibi. Ya ada ha ma ye di case no a sentence chairman. Enuti say Attorney General say chairman a flight risk because of interviewer the former counsel akwaye wo TV so a Wontumi base on argument no enfant deny chairman bail intino sa affidavit no and so supported by documents from Iyoko and also ewo ho. Another supplementary affidavit also disputes the Republic's position that Wontumi's appeal has no reasonable prospect of success. According to the applicant lawyers, the grounds of appeal are bona fide, substantial, arguable, and have a highly reasonable prospect of success. They further contend that the Republic has not identified any specific ground of appeal and demonstrated why it is frivolous, vexatious, or incapable of succeeding. In the answer, Chairman Wontumi the lawyers in fact, grounds of appeal no what they call court of appeal no moving the motion to quash the entire sentence no and declare chairman free no. In fact, it is an appealer a bona fide say in some room it is an appealer oji wachinia enye yi. It is an appealer a kura and some. Now Attorney General can say the appeal has no chances of survival. Attorney General claimed to me check grounds so krontia and a new wapi ne muntia. It has no chances of survival. And one also kind of trust other is at the end the said the appeal has no chances of survival until Yamfa refuse to Chairman Wontumi. I don't want them and Zoe and Chia Chimbe say can say to them there's nothing frivolous about the appeal, there's nothing vexatious about the appeal, and the appeal is so much capable of succeeding. Granted the bail. The affidavit also rejects argument concerning Wontumi's other ongoing criminal proceedings. His lawyers argue that the mere existence of other criminal proceedings does not establish that he would have absconded if granted bail pending appeal. They maintain that his conduct during the trial, together with his conduct in the other proceedings, demonstrates that the existence of criminal proceedings and the possibility of imprisonment will not cause him to evade the jurisdiction. And what we will say, some Attorney General to just say, Chairman Wontumi other pending cases before the High Court, and no, it has a long way of increasing his jail term. And yet the Tano Forest case and the Ezen Bank case, now lawyer for Chidemwa, it is no correct. There is this existence of other criminal proceedings, but a dear Ninaswana will say, Yaman Bela or be absconded from attending to those proceedings because in the panel crown, yan sentencing in an economy and singer. Your sentencing in your condemn or the sober. It what shows that he's going to abscond me while the passport to crown soon in each. The lawyer for chairman had demonstrated enormously or you'll be or cooperative with the rules and regulations of the court. the possibility of imprisonment enye bibia e kire say chairman aya atu anamon bi say opeso dwane di free oman. The supplementary affidavit further challenges the suggestion that Wontumi's presence is unnecessary for preparation of the appeal. His lawyers argue that as the person directly affected by the conviction and sentence, he has personal knowledge of matters arising from the evidence and proceedings. They say preparation of the appeal necessarily involves obtaining and considering his instructions concerning the evidence, factual matters, grounds of appeal, and matters arising from the judgment. They therefore maintain that the conclusion of the trial does not terminate his involvement in the prosecution of his appeal. No much say, sir, Attorney General can say, appeal in the lawyer for na yenti hu hia se physically obey present and lawyer for say there be asem no one fan ho. In fact, some factual matters on the betumi ama because asase ne ye ono na asase e no bi ko di adanse adanse wo court say chema Wontumi na adan asase ne to me di ama no brad to me krata bi enta echi enti ye pe factual matters ono na betumi di ama instructions concerning evidence ono na betumi di ama because the entire case borders on him and his presence is very much needed in any step that is taken towards ensuring a successful appeal. Enti honso no Attorney General ntumi mo emfa ntumu saakwa. Then the lawyers also contend that although the Republic has instituted multiple criminal proceedings against Wontumi, the prosecution has not identified any specific conviction in the other proceedings demonstrating that he would be incapable of complying with conditions imposed by the High Court. Wontumi's legal team maintains that the circumstances of his case, considered cumulatively, constitute exceptional and compelling circumstances warranting the exercise of the High Court's discretion to grant bail pending appeal. The affidavit argues that the application should be determined in the light of the facts of the case, the grounds of appeal, and the applicable principles governing bail pending appeal. The applicant is consequently asking the High Court to reject the dispositions contained in the Republic's affidavit in opposition and granting bail pending appeal on such terms and conditions as the court considers appropriate. The supplementary affidavit was sworn in Accra on the 17th of August 2026 and served on the Attorney General and the Director of Prisons at the Nsawam Medium Security Prisons. Any the fresh supplementary affidavit filed by Zoe and Chia Chambers, represented by lawyer Atachia.